Welcome to the Graduate Institute. I'm very pleased to see so many people today, and I salute our eminent panel. We are very happy to partner once again with the permanent mission of the Netherlands during their presidency of the European Union, and feel very honored to have with us high-level representatives from ICC. As part of their work, our distinguished colleagues from in the International Law Department offer courses both on human rights and the ICC, and work on the interaction between these topics, which are now a rapidly expanding field of study. Through their work and the work of their students, a link with legal practice is being made, which we very much value. This is why we are so pleased to have today this panel and have a dialogue between the High Commissioner and the ICC Prosecutor with the panelists, among them our distinguished colleague, Professor Carsten Stahn, and the audience. So let me wish you all a very pleasant and stimulating discussion, and I would like now to give the floor to Ambassador van Schreven from the Netherlands. Thank you all.
Thank you. Ladies and gentlemen, the mission of the Kingdom of the Netherlands, the Office of Prosecutor of International Criminal Court, and the Graduate Institute have the true pleasure to welcome you all today. It's nice to see that you came so many. It's nice to see that there's so many legal experts also in the room, so the discussion risks to be very, very interesting. As the host country of the ICC, who is based in The Hague, the Netherlands wanted to bring ICC closer to Geneva. The Genevan human rights organizations and the ICC all work on country situations, violation of human rights, with accountability as common goal. Human rights fact-finding and international criminal investigation often deal with the same issues. It's therefore very important that they know from each other what is happening and how different actors approach different problems and conflict of impunity. The Hague is very close to Geneva, but still sometimes we are not totally linked. This link between the ICC and Geneva has so far reached little attention. We are grateful that Madame Bensouda and the High Commissioner for Human Rights are here today and have showed their commitment to explore new ways of cooperation. We are also proud that most of the speakers are in one way or another linked with the organization in the Netherlands, like Professor Stahn from Leiden University and the moderator Lyal Sunga from the Hague Institute for Global Justice, who will moderate this panel discussion. Furthermore, Angela Mudukuti from Southern Africa Litigation Center and Pierre Hazan from Justice Info Net will share their experience with concrete cases on the ground, which allow us to have an interesting, balanced discussion from different perspectives. The City of The Hague has the honor to host not only ICC, but also more than 160 other international organizations, mostly directed to the legal side, international court, tribunals, arbitrage. And as Kofi Annan summed up, The Hague richly deserves its reputation as international city of peace and justice. For the Kingdom of the Netherlands, the United Nations is the primary global player and organization for peace, justice, and development. This is why the Kingdom is a candidate for the non-permanent seat of the Security Council for the 2017-2018 term, and the elections will take place in 3 weeks. So we are thrilled. Ladies and gentlemen, I will now give the floor to Mr. Sunga, who will lead you through the discussions. I'm convinced it will be fascinating, but I want to give a special thanks to the Graduate Institute. It's becoming the center of very interesting dialogue here in Geneva. There are a lot of events. If we take the last month, the number of moments we were here and we had an open discussion on a broad area, I think that the Graduate Institute is becoming kind of pillar in the whole international discussions here in Geneva. So thank you very much, the Director. And
well, it's a great pleasure to welcome you here, and thanks right away to the Netherlands and to the Graduate Institute for hosting this, and for the participation of Madame Prosecutor of the ICC and the High Commissioner for Human Rights. And I can tell you that this whole topic, this whole issue of the interplay between, or among rather, human rights, international humanitarian law, and international criminal law, norms and implementation, for me has been, for a long time, a fascinating set of issues. I graduated from the Institute many years ago, and started, a thesis back in 1986. So it's been 30 years, and I did finish it. It's all about international criminal law, and I had the great fortune to be supervised by the illustrious Professor Georges Michel Abissab. And the title is Individual Responsibility in International Law for Serious Human Rights Violations. The reason I mention it is that it was all about international criminal law, but you don't see even the word criminal or criminal law in the title. And you might think that's maybe an odd way to pitch a thesis with a topic that doesn't even mention the word criminal, and it's about international criminal law. And the reason for that is that back in the mid-1980s, if you were researching international criminal responsibility, individual criminal responsibility, you were directly led to the norms of international human rights law and international humanitarian law. Because in those days, international criminal law did not really exist as a discrete normative system or part of public international law. There were norms, as we know, that go back even thousands of years that touch on criminal responsibility for serious violations. And there was the trial of Peter van Hagen way back in 1474, and developments, and there's the great Nuremberg and Tokyo trials in 45, 46, etc. But the international community had not really, since Nuremberg and Tokyo, been able to develop international criminal law as a full normative system or one of implementation. Why? Well, the Cold War, lack of international cooperation, very contentious scenario in which to do these kinds of things, and international criminal law, like criminal law at the domestic level, requires a lot of cooperation. And so, the International Law Commission was producing the draft code of crimes against peace and security of mankind in 1951 and 1954, and some other drafts. But basically, the project was not going very far because of a lack of political will at the international level. And so international criminal law was more hypothetical rather than practical reality. And I remember some very high-level people saying, it's a nice thesis you did, but it's really impractical. It's kind of a dream. Nothing's happened since Nuremberg and Tokyo. And as we know, everything changed very dramatically with the establishment of the Security Council's decision in May, 1993, to establish the ICTY. Lucky for me, because I hadn't seen that coming, but it was nice to see a huge transformation from, norms that you could gather from human rights and international humanitarian law. Suddenly, international criminal law was a reality, a very practical reality. And so from the normative point of view, that was very important. Then, you know, if I might permit another personal aspect to this, is that in terms of implementation, in 1994, I was asked by the then High Commissioner for Human Rights, José Elalasso, to support the Security Council's Commission of Experts on Rwanda to investigate the genocide and associated violations and draft reports for the Security Council's Commission of Experts. Of course, we did massacre site investigations, and you know, we're talking about 800,000 or 1 million civilians, mainly Tutsi and moderate Hutus, slaughtered, as we all know there. Now, what's the point I want to make is that all this work that we did, which was mandated by the Security Council, was serviced by OHCHR. In fact, José Elalasso became High Commissioner on 5th April, and then 1994, and then the genocide was kicked off and began in 6th April, the very next day. And he had zero budget at the beginning. And I remember those days. But if it weren't for the human rights system, we wouldn't have gotten so far as to even have a Security Council mandate to investigate the violations. There were special rapporteurs, country rapporteurs, and thematic rapporteurs that were signaling the violations even before the genocide started. Some of those reports were ignored or given very little attention. But that could help marshal political will for the establishment of the ICTY and the ICTR. So the UN human rights system has got a very intimate connection in terms of norms and implementation. And it goes back to the founding of the ad hoc international tribunals, as well as eventually to the International Criminal Court as well. And so the connections are there, and we did lots of investigations. But the question was, well, what's going to be done with all this material that we've gathered? Going through massacre sites and interviewing witnesses and consulting with people in a wide range of sources. Because people said, well, you're not international criminal investigators. So, you're human rights investigators. Human rights investigators look for mainly issues of responsibility of the state. And they don't collect evidence, or let's say I should say information, that may be transformed into evidence, possibly, if it's properly corroborated. And human rights investigators don't normally do that, although that practice has changed in the last 10 or 15 years. But early on in the mid-1990s, human rights investigations were very much different, and they still are, for a different purpose, than international criminal investigations, which are for prosecution. Also, chain of custody. We were not marking down clearly, the sources of testimony, the individuals we talked to, so that they could be brought before a court later on. They could be examined and cross-examined for the purposes of an international criminal trial, if not at domestic level. And corroboration was not the same, etc. So the common goal of accountability between human rights and the ICC is quite clear. And let's not forget about international humanitarian law either, because the grave breaches of the 4 Geneva Conventions and provisions in Protocol 1 give a lot of the normative substance to international criminal law. All that is clear that there's a common goal of accountability. But it's also clear that there are gaps, because when there are atrocities, the people on the ground are most usually the human rights actors, the NGOs and others. They're there. And if they weren't directly involved or victims, they are very close at hand and they know the situation. It may take years for international criminal investigators to show up, if they ever show up. But on the other hand, we look to solid enforcement of international criminal law as a very, very important thing. So there are gaps, and that's why that's the rationale behind promoting dialogue. It's very essential to have dialogue between the ICC and human rights actors for this reason. And so that's why we're here, and that's why it gives me also great pleasure to give the floor to the Madam Prosecutor of the ICC, Fatou Bensouda. Thank you very much.
Your Excellencies, Your Excellency, High Commissioner, distinguished guests, ladies and gentlemen, allow me at the outset to express my utmost appreciation to the Graduate Institute for hosting this important and timely discussion, in which I am honored to participate along with such distinguished co-panelists and cherished friends. I would also like to express my deep appreciation to His Excellency, Ambassador van Schreven and the Dutch mission in Geneva for their vision, their tireless efforts and support in organizing this event. In my brief opening remarks, I wish to reflect on the role of the International Criminal Court in the fight against impunity and pursuing accountability, as well as the need for enhanced cooperation between the ICC and the Geneva-based human rights bodies to ensure accountability for perpetrators of atrocity crimes. My task as prosecutor of the International Criminal Court is to fulfill the mandate that was vested upon me by more than 120 states during the negotiations in Rome Statute in 1998 that led to the adoption of our founding treaty, the Rome Statute. This mandate is straightforward. It is to investigate and prosecute those most responsible for committing atrocity crimes where we have jurisdiction. I am most committed to continue to fulfill this mandate without fear or favor. The objective of this mandate is twofold. First, hold those most responsible accountable, and second, by so doing, serve as a stark reminder to would-be perpetrators that they too will be held to account should they commit such grave crimes and thus contribute to the prevention of such crimes. The Rome Statute created a system of mutual responsibility in the implementation of international criminal justice. States parties, on one side, accept their primary responsibility to investigate and prosecute these crimes. The ICC, on the other side, operates as a court of last resort, intervening only when the national authorities are inactive or otherwise unwilling or unable to genuinely deal with these crimes. This is what we call the principle of complementarity, which is very much at the heart of the Rome Statute system. Impunity is no longer an option, and anyone, regardless of their position or rank, may be held individually accountable for their criminal acts. No one is above the law. In addition to these cases, we are currently, in addition to the cases we are currently investigating and prosecuting, we are undertaking preliminary examinations in Afghanistan, Burundi, Palestine, Iraq, Guinea, Nigeria, Ukraine, and Colombia, with a view to determining whether there is reasonable basis to proceed with an investigation. In all these situations, we are looking at alleged crimes committed by all sides and will not hesitate to open investigations if the legal criteria of the Rome Statute are met. We are guided by the principles of independence, impartiality, and objectivity in all that we do. In nearly 20 situations covering wide-ranging geographical regions, and with often very challenging security considerations, my office's task is one of huge proportions. Genuine and effective cooperation from states parties and other partners is critical. The enforcement pillar, that is the enforcement arm of the Rome Statute, lies with the states parties. I would particularly like to emphasize the need for cooperation and assistance in the executions of warrants of arrest issued by ICC judges. The pursuit of accountability for atrocity crimes is not a task for ICC alone. The ICC is only one, albeit a key part of the global accountability system. States and other international actors all have international important roles to play. The unfortunate reality, however, is that in many situations, states have failed to shoulder this responsibility. Increasing the political will and strengthening domestic capacity to investigate and prosecute atrocity crimes is critical to curb impunity. Only when states fully assume their primary responsibility in this regard will we succeed to systematically bring justice and accountability to victims. That is when we can finally say that laws will no longer remain silent in times of war and conflict. And here I would like to emphasize the importance of the cooperation between the Court and the United Nations and Geneva-based human rights bodies for the achievement of accountability both before the Court and at the national level. I would like to notably recognize the multifaceted activities of the Office of the High Commissioner for Human Rights, but also many other actors. Geneva is a unique environment where so many organizations from their respective mandates work towards the inherently shared noble human goals of peace, justice, and respect for human rights and ensuring accountability. However, there are many ways in which the interaction between the respective institutions, academia, media, and civil society in the fight against impunity could be further enhanced, and we must explore and exploit these possibilities. Ladies and gentlemen, let's put the discussions in focus here. We are talking about working together to counter the world's most heinous crimes that threaten peace and stability. And I look forward to the discussions during this panel on how we can continue our efforts to strengthen our coordination and resolve to fight against impunity, to hold perpetrators accountable. As I often say, that one of humanity's proudest moments surely must be the creation of the ICC. It is not perfect by any means, but it must be supported to be able to carry out its work as intended. We owe it to ourselves, our children, and to future generations to nurture the ICC so that it carries on with this crucial work to fight against impunity and to foster the Rome Statute system of international criminal justice. I thank you.
Next is the High Commissioner for Human Rights, Zeid.
Thank you, Lyal, Excellencies, Prosecutor Bensouda, Monsieur le Directeur, who left just now. Ladies and gentlemen, it is a great pleasure to be joining Fatou Bensouda and the very distinguished panel on this stage to discuss the complementary nature and relationship between human rights and international criminal law. But there's also a sort of common overlap between the work that we do, and it's the fact that Fatou Bensouda and I have two of the most meaningful, rewarding, and deeply important jobs in the international community. But equally, we are two people under considerable stress given the exposure to the enormous human suffering that we are witness, and then the resistance and the pushback of member states, many of them. And so when I was raising these issues with a group not too dissimilar to this one about 6 months ago, one of the students said to me, "So High Commissioner, how do you cope with the stress of this job? We know what inspires you, but how do you cope with it?" And I said, I don't really know. I mentioned that my wife, who lives in the United States with my children, called me one morning and she said, "How are you feeling?" And I said, "I feel terrible. I've been dealing with the victims of torture the whole week. I've had difficult discussions with governments, and I'm finding it an extremely taxing job. And she said, if you're feeling so low, why don't I call up my mother in England, and she can come and spend a few days with you. And she said, if you really feel low, she can bring her sister along. So I said, you know, I suddenly feel much better. And when I said this to a group of students and a group of academics, a lady came up to me afterwards and said, High Commissioner, you know, in this day and age, we don't make mother-in-law jokes. And I said, but it's not a joke. It really did happen. Now, as Fatou said, by every measure, the establishment of the ICC was a pivotal moment in the history of humankind. And many of us who are in this room had the privilege of playing a minor role, because it was a collective effort and it was an extraordinary time. And of course, it was a moment perhaps recognized most acutely by the teams of lawyers who drew up the statute, whether they be in the International Law Commission, the Office of Legal Affairs, and we're very proud to have, of course, the Irish ambassador here, who was at one stage the head of legal affairs at the UN, and also activists, journalists, human rights defenders, and lawyers, the length and breadth of the international community. What I think we over-anticipated is how the rest of the world would take time to recognize what a transcendent moment this was in the history of humankind. And the fact that they're catching up now, I think, is very telling. The court, after all, embodies the general international consensus that genocide, crimes against humanity, war crimes, and soon aggression are too grave to be left unpunished, that their victims are worthy of interest and consideration, certainly, but that's not enough. They are worthy of our deepest respect, of remedy. And the creation of the court resulted from these efforts to end indifference to the victims' pleas for justice. And the preamble of the Rome Statute declares that its drafters were, and I quote, mindful that during this century millions of women, children, women, and men have been the victims of unimaginable atrocities that deeply shock the conscience of humanity, and affirmed, and I quote, that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured. And it is clear that justice should primarily be achieved through national processes, as Fatou Bensouda just said, and the primary responsibility to prosecute gross violations of international human rights law and serious violations of international humanitarian law, and to prosecute international crimes, continues to rest with states. According to their legal obligations under several international treaties, such as the Convention Against Torture, to take but one example, all states should persistently engage in efforts to fight impunity. And yet, all too often, impunity prevails at the domestic level, and this is particularly the case for the worst violations, those that may amount to international crimes. These crimes, too, often go unpunished for various reasons, including inability or unwillingness to investigate or prosecute them, or mere political expediency. And in these circumstances where states are unable or unwilling to fully investigate certain crimes, of course, as we just heard, the ICC's mandate gets activated. In this context, the ICC and human rights actors, including my office, OHCHR, work in the same direction in seeking to fight impunity and ensure accountability, especially for the most serious violations. While we are, of course, separate, independent entities with our own respective mandates, we have indeed those or these objectives in common. And our mandates are distinct and complementary. And I'd like to point out briefly to an important area of complementarity between the ICC and my office. And it relates to the prevention of crimes and their deterrence. And we all hope to live in a world where genocide, crimes against humanity, and war crimes, including then aggression soon to come on board, are unthinkable. Can we do something to ensure that these crimes are prevented? And I believe it is the right answer to say that we can. Often the signals that these crimes may be about to occur are the same: entrenched patterns of discrimination, terrible inequalities in a society, little or no rule of law, and these human rights violations in a given location can often signal that international crimes may be making a terrible entry. Acting when these warnings are there is fundamental to avoid the escalation of critical situations, and this is where monitoring and reporting the work done by my office is important, and it signals to the UN those situations where a serious risk of escalation exists. There are many other areas of complementarity between the ICC and my office, and I will just mention in the closing part of this short statement two. First, my office supports the Universal Periodic Review, where the examined states are often called upon to accede to the Rome Statute or adopt implementing legislation. And this is a very practical way in which human rights mechanisms promote accountability in general, and the ICC in particular. Second, my office works with states to ensure that they have effective and efficient justice systems and that victims have access to justice. And this is an important area of our work and one of our strategic priorities. And I look forward to this coming discussion. Thank you so much.
You for your presentation.
Your Excellency, Director of the Graduate Institute, Madam Prosecutor, High Commissioner, it's a privilege to be here today. Today is I think, symbiosis between The Hague and Geneva. I don't know quite which perspective I should present today. The Hague perspective, given that I also work at Leiden University, or the Geneva perspective, given that I'm here as visiting professor of the Graduate Institute. So I thought I should try to make the best of both traditions. And I would like to address three issues today. First of all, the issue of accountability. Secondly, the synergies between the human rights community and the international criminal law community. And lastly, education and research. First, accountability. We live in an age of accountability. Hardly any violation goes unnoticed. And I would argue that we're moving towards a thicker conception of accountability. It has four dimensions: justice, truth, effective remedies, and guarantees of non-repetition. The main challenge is how to make all of them work. How can we do this? Criminal law is typically focused on the perpetrator. Human rights law is more centered on the victim. So, my first claim is that the two are actually converging. And let me start with a personal experience. My first experience in international criminal justice emerged in 2005, when the pretrial chamber of the International Criminal Court issued a warrant of arrest against Dominic Ongwen. You see the 2005 warrant here. At the time, I was working with the pretrial chamber. The judges came to the conclusions that there were reasonable grounds to believe that Ongwen committed crimes. But it's only 10 years later that the ICC actually started its proceedings. There were peace talks in Uganda, the Juba talks. Peace mediators appealed to the ICC to withdraw the warrants. So was it a mistake to issue these warrants? I would say no. I would say the warrant in itself had a very important function because it broke a wall of silence. It made certain violations speakable that others considered to be unspeakable. The warrant remained unexecuted for a decade. But this is justice. Justice takes time to produce its effects. So one shouldn't try too easily to criticize the ICC for moving too quickly. Let's turn to the second picture. Sorry, we should go back. One back. Yes. The statement of Florence Ayot. Florence Ayot is one of the former bushwives of Ongwen. She actually took the floor when Ongwen was arrested, and she spoke in favor of Ongwen. She said that Ongwen should not have been sent to the ICC because it was a government which failed to protect Ongwen when Ongwen was a child. And I think this really shows us one of the fundamental dilemmas of international criminal justice. On the one hand, Ongwen is a perpetrator. On the other hand, Ongwen is a victim. So how can we deal with these different challenges? And I would argue that the justice process really needs to reconcile these tensions between victims and perpetrators. Earlier this year, the pretrial chamber had to issue its decision. It said it convicted Ongwen to trial. It recognized forced marriage as another inhumane act. And it forced the ICC also to engage, of course, with the counter-narrative, the fact that Ongwen is also a victim. This is an issue which will come out probably at sentencing, when we consider to what extent there are mitigating circumstances which might explain the situations. Why do I show these two pictures? I think these two pictures show, in my view, the most important development of the past decades. First of all, justice is not only about the perpetrator, it's also about victims. And secondly, human rights law is not only about victims, but it's also about perpetrators. This brings me to the second point, the synergies between The Hague and Geneva. And I would argue that most of the synergies between the two exist not only at the center, the trial, but at the peripheries of the justice process, namely preliminary examination and investigation. The prosecutor has already mentioned which situations are under preliminary examination. It's easy to criticize the ICC for the fact that it only had 3 convictions and 1 acquittal. But I would argue that some of the most important synergies between The Hague and Geneva are before the case actually goes to trial, namely in the context of the preliminary examination and the investigation. At preliminary examination, we see 8 situations. Most of them are highly complex. Some of them involve permanent members of the Security Council. And synergies start here. Like other international criminal courts, the ICC is often criticized for relying only on the work of non-governmental organizations. But reports from human rights institutions here in Geneva are key for analysis, are key for building a case hypothesis and for framing investigations. So that should be the very starting point, I think, of our inquiry. Secondly, let's move on to investigation. We see that there are 10 situations currently under investigation. And investigations often continue over years. The ICC may benefit from the work of fact-finders. We've seen successful collaboration between commissions of inquiry and international criminal proceedings. Both of them pursue distinct purposes. Human rights fact-finding should not be confused with international criminal justice. But this does not mean that there are no overlaps. One of the most successful examples is obviously the Commission of Inquiry in relation to Darfur, led by the late Antonio Casese. The Commission shared an entire truck of documents with the ICC, which was then very helpful for the Darfur situation. And most of all, there was also afterwards a debriefing with members of the Commission with the ICC. And it's precisely this type of relationship which might be helpful, I think, in the future. Another situation, ICC engagement coincides with ongoing commissions of inquiry. For instance, Libya. One lesson to be drawn from this is that it might be helpful for international criminal justice, particularly to benefit also from some of the interviews and forms of consent that have been expressed. If there was, for instance, at the end of the questioning of interviews, a form which would provide an agreement to disclose certain of the material with the ICC, that certainly improves and helps the ICC in its investigation. The third area is a new field, the area of reparations. The ICC has a thicker vision of accountability than some of the other courts, because punishment is not only tied to accountability of the perpetrator, but it comes with a direct expression of accountability vis-à-vis the victims. Here again, the human rights bodies have a huge and significant jurisprudence in determining harm and in determining the relationship between individual and collective reparation that might be very helpful to international criminal justice. This brings me to my last point, education and research. Research collaboration helps to build bridges between different communities and different professional communities. And there are several examples. In the past years, we've seen projects seeking to refine the working methods of commissions of inquiry, of archiving. There is new foundational research, for instance, also here conducted at the Geneva Academy, on what are the common legal foundations of modes of liability. And it seems to be these projects that may help us to bridge some of the gaps. Finally, there are a lot of students in the room, students from Geneva, students from Leiden, students from other communities. International criminal justice produces wonderful opportunities for all of you to get involved. I just mentioned the example of the ICC moot court competition, which this year hosted 59 universities from 44 countries, and 1/4 of the universities were actually non-state parties. And competitions exist in Spanish, Russian, and Chinese. So this really is, I think, a very important form of putting complementarity into practice, and I think it provides a possibility for all of us, and it shows that everyone in this field can make a difference. Thank you.
Thanks very much, Carsten. And Angela Mudukuti, who's come all the way from Joburg, from Johannesburg, to speak with us today. The floor is yours.
Thank you. Excellencies, High Commissioner, Madam Prosecutor, distinguished guests, and ladies and gentlemen, thank you for having me. It is indeed a pleasure and a privilege to address you today. As introduced, my name is Angela Mudukuti, and I work for the Southern Africa Litigation Center, a human rights organization that focuses on ensuring that countries obey their domestic and international criminal law obligations. My role today is really to discuss civil society based on our efforts to support the International Criminal Justice Project. Civil society across the world have been instrumental in the development of international criminal justice, from the establishment of the ICC itself to running domestic litigations in pursuance of accountability for international crimes. At the Southern Africa Litigation Center, we adopt 3 strategies: strategic litigation, legal development, which also includes encouraging the signing, ratifying, and domestication of the Rome Statute, and relentless advocacy. With three tools in place, we believe that we can further the International Criminal Justice Project. The example I will briefly discuss today, based on our work in South Africa. President Bashir of Sudan, who was wanted for genocide, war crimes, and crimes against humanity, came to South Africa in June 2015. South Africa, as a signatory to the Rome Statute and having domesticated the Rome Statute, had a duty to arrest him. When he arrived and we received confirmation that he had not been arrested, we went to the courts on an urgent basis, seeking the enforcement of the arrest warrant, hoping that President Bashir would be arrested and subsequently transferred to The Hague. We were in court over a weekend, and of course, the state's first move was to ask for a postponement. We then decided, well, if we're going to postpone the matter, then we need an interim court order stating that President Bashir is not to leave the country pending the finalization of the legal process. The next day, we were back in court again, and after arguments from both sides, the court ruled that South Africa should arrest President Bashir for subsequent transfer to The Hague. Immediately after that, the state informed the court that, oh, we think he's just left the country. Despite his escape, a strong precedent was set. the South African High Court confirmed that South Africa and all the other signatories to the Rome Statute are obligated to cooperate with the court, particularly with regard to pursuing international fugitives. This precedent was also confirmed by the Supreme Court of Appeal. Currently, the state has taken it on appeal again to the Constitutional Court, which is the highest level of adjudication in South Africa, and we're waiting to find out whether or not the court will hear the matter. But as it stands, an important message has been conveyed. It underscores the reason we are all gathered here today, and that is that the ICC cannot bear the burden of administering international criminal justice on its own. It is evident that fighting impunity is a responsibility that rests with us all. It is up to all the stakeholders, civil society, governments, international organizations, to support the International Criminal Court and the International Criminal Justice Project. It's up to all these stakeholders to ensure that true complementarity and a fair, consistent application of international criminal law is witnessed. To give meaning to this idea of complementarity, each and every cog in the wheel must play its part. As a representative from civil society, I am acutely aware of the role that we must play. We are non-aligned, independent bodies. We have the space to act where authorities are perhaps unwilling or unable, or where preference for policy and diplomatic concerns overrides accountability and justice. Where they fail, we must act. The next example that I'll briefly touch on reinforces the importance of having the correct legislation in place. This is another case we worked on involving crimes against humanity perpetrated in Zimbabwe by Zimbabweans against Zimbabweans, but to be investigated in South Africa. And this is possible because South Africa, in its domestication of the Rome Statute, included an element of universal jurisdiction. So therefore, because the witnesses were present in South Africa and because the suspected perpetrators traveled to South Africa frequently, there was a case that could be built. We collected evidence of torture committed as a crime against humanity and presented it to the National Prosecuting Authority in South Africa, and instructed them that in terms of South African legislation, they were obligated to investigate the case. Of course, they declined, and we were forced to take that refusal to investigate on judicial review before the High Court. We were in the High Court, the Supreme Court of Appeal, and finally the Constitutional Court, where it was reinforced that South Africa, in accordance with the South African ICC Act, had a duty to investigate the crimes documented in the dossier. Without the necessary legislation, this precedent would not be in place. Zimbabwe in particular is what I call a justice void. At the time, there were no domestic initiatives to investigate the crimes. Zimbabwe is not a signatory to the ICC, and also Zimbabwe has a very tight and cozy relationship with China, which prevents a United Nations Security Council referral. So at that time, the prospects of justice were slim to none. And as a Zimbabwean myself, I can testify to this. But thankfully, in neighboring South Africa, the correct legislation was in place, a framework designed to pursue suspected perpetrators of international crimes, and a civil society organization that was prepared to take up the challenge. The third avenue that I will briefly discuss is relentless advocacy. Advocacy is required to dispel the misconceptions about the ICC, to correct this unfortunate stereotype that it is targeting Africa. Civil society needs to educate parliamentarians, lawmakers, policymakers to inform them of the limits of the jurisdiction of the ICC, to make it clear what the ICC can and cannot do, and with that knowledge in place, remind them that all of us are responsible in the fight against impunity. In conclusion, I will say that we all have our roles to play, and civil society must work effectively with the United Nations and the ICC to encourage dialogue, constructive criticism, and further engagement. Understanding how all these spheres come together is crucial to the survival of the International Criminal Justice Project. And it's seminars like this that remind us that there's much needed synergy and continued dialogue. And with that in mind, I look forward to your questions and to furthering the discussion. Thank you.
Thanks very much, Angela. And now we move to Pierre. Please take the floor. Thanks.
Excellencies, ladies and gentlemen, it's a great pleasure to be with you today in this magnificent building. I used to be a student like Lyal of the Institute. The Villa Barton was not bad at all, but this is really nice. I'm here today to address the relation between international justice and media. I would like to start by a very personal memory. For a long time, I was a journalist. More than 20 years ago, I was covering the war in former Yugoslavia, and I went also in Rwanda right after the genocide, and in many other places. And in all these places, I spoke to many people, simple people or intellectual people, or from very different fields. And we have very basic questions, ethical questions, and expectations about justice, expectations about truth, expectations about trying to do some meaning of what happened in their own life. What happened, what's the fate of the missing people? What does it mean, the new international tribunal which has been created by Security Resolution 955 or 808 or 827? What does it mean really? Will it impact on our life, and how? And I was fascinated and sometimes was wondering about this huge expectancy which was very difficult to fulfill. So when a year ago, or a bit more than a year ago, Fondation Hirondelle came to me. Fondation Hirondelle created many radio stations in conflict situations and post-conflict situations, independent radio stations, to provide free and fair information, and said, well, Pierre, we would like to create a media to address these questions of justice and truth and reparation. Let's try to do it. I say, great, let's try to do it. And I wanted to create something which will be a platform where academics, on one hand, practitioners and journalists will try to create a more informed conversation. Conversation in French, conversation in English, and since today, conversation also in Arabic. And it happens also because from the beginning, we had the support of two great universities, Harvard Humanitarian Institute and also the Oxford Transitional Justice Research. And very soon we'll have for partners the Graduate Institute with the new Transitional Justice Program. So we believe that it is necessary to link the right to information with the right to justice. Because really people are starving to get more information, to make more sense of what is happening in their own life. And I think it is even more important today because international criminal justice is taking place right on the spot. We are no more in, as Lyal mentioned, like in Nuremberg or in Tokyo trial. Crimes are happening today in Burundi, and the ICC, as it has been mentioned by Mrs. the Prosecutor, has opened a preliminary investigation. So that is creating a very special situation. Crimes are being committed, then you have already an international response, and the belligerents fully understand the strategic importance to win the narrative battle. The narrative battle on the judicial front and the narrative battle on the media front. Both of them are interlinked, obviously. And I will give you a very simple example. For me, it's kind of paradigmatic example. It's what happened with the Gaza flotilla case just a few years ago. You remember the story, and what for me is really interesting is you can think about Israel, Palestine, and Turkey. Each of them try to find, they were shopping for courts and fora. There were 6 reports which have been produced on this case. Every country, every belligerent or every party was trying to get its message across, its version of truth across. And so we had 2 quite different, actually, UN reports on the Gaza flotilla, one from the Ban Ki-moon report, the primary report, and also the Council, the Human Rights Council report. You have 2 Israeli reports, 2 Turkish reports, and even the ICC was asked to intervene. So you see how the belligerents want to use the public space in order to put their version of truth ahead, because they know it's really critical. Otherwise, the country risks to be isolated, and the government may risk also to be brought down. So basically, for each stakeholder, it's really critical, the role of the media and the role of the judicial front. So this is happening also in a very in an environment which is changing radically with new technologies. You know that the Kony video has been seen on YouTube by 21 million people. 21 million people. So it has a political impact. And we see also from a different perspective, and although the Kony video, also, although it misrepresented the conflict, it has this political impact, and we can discuss about that. But I think more interestingly, we see that technology today and media technology can help to collect evidence. In Syria, people with their smartphones were able to collect a lot of evidence, days after days, and unfortunately years after years. We see with new apps being created to collect evidence also. We see organizations like Witness, which is teaching how to learn video to document human rights violations to bring changes. Although these developments are very, very important, but they come with a price. The price, it's not always very professional. No professional standards are being applied. The risk of manipulation is also real. But despite all, we are in a very new world, a highly complex world, with an enormous amount of information and with not much verification. So, in this context, the media is a key actor, but it's far from being homogeneous. Media could be perpetrators, and we all know that the genocide in Rwanda happened also because of the hate media of Radio Télévision d'Émile Colline. But more recently, there have been hate media, warlords in Afghanistan, in Somalia, in other countries have been hate media to disseminate and to incite violence. Media could be victim today in Burundi, journalists are being victims in Syria. But media could be also a partner to international criminal justice. And here I would like to give 3 examples. One, the first person which was ever convicted by the ICTY, the International Criminal for former Yugoslavia, was Duško Tadić. And Duško Tadić was found actually by a German journalist. Dražen Erdemović was a soldier who killed with his comrade of killing squad 1,000 people in Srebrenica in one day. And he met an American journalist, and because of that, the ICTY was able to locate him and to exfiltrate him and to have him in The Hague. And maybe the last example, it's a short video, the 2 minutes I would like to show you. Just almost by chance, it's a long story, I will make it very short. With someone from Human Rights Watch, some of you I'm sure you know, Reed Brody, we found maybe the smoking gun of the Hissène Habré case. It was quite a shock. It was exactly 15 years ago. And as you know, this week, this very Monday, the verdict happened. So if it's possible to see this short video.
De soutien du gouvernement tchadien pour débloquer les preuves, pour faciliter la coopération avec le juge belge, pour protéger même des témoins qui sont ici au Tchad. Donc, pour des raisons tactiques, on ne parle jamais en fait de ces choses-là.
Ces choses-là, un terme pudique pour
So
laisser
here we
entendre
got
qu'à terme,
access for
c'est
the
l'actuel
first time
président
to
Idriss
the
Déby
DDS,
qui pourrait
the
être
political
poursuivi
police, and
lorsqu'il ne sera
suddenly
plus protégé par l'immunité
you will see what you are
accordée
going
au chef
to
d'État en
find.
exercice. D'où l'attitude ambiguë du gouvernement qui redoute une justice qu'officiellement il fait mine de vouloir. Placé sur la défensive, le gouvernement tchadien laisse exceptionnellement Reid accéder à ce qui fut le siège de la police politique d'Hissène-Habré, la terrible DDS.
So actually, that's the archives of the political police, with all the names of the people who have been killed, the chain of commands, the organigram of terror, everything, which was then transmitted to the Belgian bench, then to the Senegalese courts in the extraordinary chambers in Dakar. And really it was quite a shock to... The first piece of paper I will remember all my life we took from the floor was a letter to thank the CIA for training interrogators.
Des détenus, des ordres, des perquisitions, des enquêtes. Vraiment, c'est un trésor ici. C'est un véritable trésor pour nous ici.
Okay, thank you.
I'm watching my clock because I would like to maximize the amount of free-for-all discussion, but we'll start off with maybe two questions to the ICC Prosecutor and the High Commissioner before we open things up. And very broadly, and first of all, thank you all for your opening statements, which are very multifaceted in their totality. In terms of the greatest challenges to impunity that from your different institutional perspectives, what do you say would be the challenges for fighting impunity, and specifically, if you have some strategies in mind that would strengthen coordination between the ICC and human rights actors, including the Office of the High Commissioner for Human Rights, in terms of meeting those particular challenges. I call on the Madam Prosecutor first, and then I'll come to the High Commissioner.
Thank you very much. I think we are witnessing currently a lot of pushback against the fight for accountability and justice. There is pushback, and there are various ways of doing this. We see what the NGOs and the activists are going through. We also know even the High Commission office, the pushback that it is receiving. But I will concentrate on ICC. I'll focus on the challenges that we face as a court, which is really affecting our work. And firstly, I want to talk about this issue of cooperation. It is important for ICC to receive cooperation, and effective cooperation for that matter. It is crucial for the work of the court that it is supported first and foremost by the states parties who have created this court. They have that obligation to support the work of the court. On the contrary, what we are seeing in certain angles is deliberate attempts not to support the work of the court, either by not providing the information we are requesting for, or delaying that information, or pretending to give us information when it is not that, and various other ways that directly affects the cases that we are handling. This is a big challenge that the court has already experienced. But again, another one is politicization of the work of the ICC. ICC is a judicial institution. Of course, we operate in situations that are highly politically charged. This is a fact, but that does not mean that the ICC's decision are based on those political considerations. However, whatever step ICC takes, whatever decision ICC takes to move in certain jurisdictions, to open investigations or open preliminary examinations, because
our jurisdiction has been met, the legal criteria under the statute has been met. This, however, will always be interpreted, that decision that the office takes or the judges take is always interpreted because as a political decision, that it is taken because of one reason or another. And what this does, really makes, how it affects the court's work directly is that it has a reputational risk for the ICC, that this is a political institution and it is taking decisions because of politics. This is another challenge that we face. This whole accusation of African bias, for example, that ICC is only targeting African leaders, that whole accusation, we all know that it's based on political considerations. That's why it is, the accusation is made and not backed by the facts on the ground. Why ICC is in Africa. They always overlook that, the fact that the countries, 5 countries in Africa have already requested the ICC to intervene in their situations, asking for ICC, because they are state parties, and they can do that. They can request an institution that they are part of to come in and investigate and prosecute crimes. But instead, it is turned on its head and say that it is ICC that is going after African leaders, that is targeting African leaders. I always say that, in fact, if you really look at the facts and how it happened and how these cases came to the ICC, I say Africa is going after the ICC. They are requesting the ICC to come, and not the other way around. So this is also another challenge that the court is facing in order to be able to do its work. Another area is resources. Resources is also a big challenge for the court. We all know that the demands that are made on the court is growing. There is a lot of expectations that the court would intervene in some situations, even where we don't have jurisdiction. There is expectation that ICC should go there. But that demand is not matched by the resources that we need to work on the cases. And as a result, we have had in the past, and I'm sure we will do it also in the future, we have had to prioritize certain situations over others. So these are some of the, just the few challenges that I can talk about. Security is another thing. Most of the time we are investigating these cases in situations of ongoing security, ongoing insecurity, ongoing conflict. And of course, it becomes very important for the protection of the people we talk to, as well as even the staff of the office. Their protection is huge. We try to overcome that, but it is still a very huge challenge that we have to deal with. In brief.
Thanks very much. Before I give the High Commissioner the floor, just to put it in more, maybe I turn from moderator to agent provocateur. And, several governments have even gone so far, as we know, to denounce the ICC as a neo-colonialist tool. Is there something, in your opinion, that from the High Commissioner's side that could be done in terms of countering some of these misperceptions and half-truths? And because there is a risk, and we've seen it, that constituencies in certain countries become swayed by these kind of arguments which play to certain populist notions of resentment, etc., some of them grounded in fact of colonial history, etc. But are there some areas where there could be greater coordination and some kind of contribution from the human rights side in this vein?
I think it's a very dangerous moment in time. There is a growing worship of simple appearance, the appearance of being wedded to a human rights agenda, the appearance of being against impunity, the appearance of a belief in an international system. But what we see happening is a growing abandonment of all of that. And the wide difference and a gulf that exists between what is said and what is actually done is putting this planet in deep jeopardy, deep jeopardy. The central and malignant disease which we experience internationally is one of hypocrisy, one of cowardice and timidity. We support our friends, we denounce our enemies, we pay lip service to international law and rule of law. We publicly go and speak at international fora that we're for collective action, that we're for the collective good, and privately we work on narrow agendas with our people. We attribute simple sort of slogans to complex situations. We denounce others, we discriminate, and we repress. And the world is in an extremely difficult moment. Whatever pressures we feel in human rights are amplified when it comes to the world of international criminal law. And it's no, I think, stretch to say that if we don't make this succeed, we will have to, and if this planet still exists in 100 years, if we haven't blown it up, we will have to redesign it from where we are now in any case. The world needs enormous leadership and a profound understanding of how critical a situation we're in at the moment. And only then will we begin to wake up and realize you cannot simply get through the future by simple attachment to the appearance of doing something, but a real commitment to doing the right thing. If you do not stand up for the International Criminal Court, you might as well be standing next to the soldier raping the young girl in a conflict and do nothing. Or you might as well be standing next to someone who is being shot and being dismembered, because it's almost the same thing. And so you make a choice. You know, the arguments levied, as Fatou Bensouda, against the court are spurious at best and revolting at worst. And we have to reverse it, and we need the courage of many of you and beyond you to make this work.
Thanks very much. Very interesting and fascinating and pertinent comments from both of you. I would perhaps maybe follow up on that last point, maybe for the entire panel, but I would invite their very succinct responses at this point so that we can leave you maximum time for questions from the audience. But just picking up on the notion of bystander accountability in a way, morally, ethically, and perhaps even legally. We've looked around and we see certain conflicts that maybe started fairly local, amount of violence, and then became perhaps non-international armed conflicts, and then became internationalized and are full-blown international armed conflicts. And I'm talking about also the rise that you see. You can look around in different countries, and just for the last 5-6 years, deaths are 8,000 going up to 10,000, and I'm looking at those and saying, well, is the international community, when and how will it intervene? Because we're seeing obviously serious violations that are Rome Statute crimes. And where do you see, I'll just invite the panelists for their succinct comments, in terms of the structure of international law right now and international, perhaps collective security, its weaknesses, its failures, where would you pinpoint the main issues in terms of, well, the international community and is very much in a bystander situation in many cases. We know there's violence. We see it's very predictable that this is not being dealt with at the domestic level, and it very quickly, over some months, gets out of such control that we're talking about tens of thousands and then over 100,000 deaths or more. And still the international community does not act. So I just leave that in a very open-ended way and invite some very quick comments from you. Maybe starting with Angela, and then I'll work my way this way.
Thank you. I would have to say that we'd really have to look at it on a case-by-case basis. My sense is that it's not that the international community is behaving like a bystander, but that there are massive hurdles preventing international intervention. There are conflict zones where you can't even come in if you're not from that country, where civil society have been silenced, where your social media account has been shut down, where the police don't take your allegations or your reports seriously. So I feel like there are, in particular situations, there are massive restrictions that prevent anybody from outside from coming inside. That being said, that doesn't absolve the international community of being proactive. And I think, you know, as we sit here today, there are a lot of international organizations that are being proactive and doing their best in very difficult situations.
Thanks, go ahead.
I think your fundamental supposition that there is a community to begin with is wrong. There is no community. There are interests, strategic interests, commercial interests, rapacious, pernicious, and a competition that is overwhelming the ability for those who think that there is a community to overcome these limited interests. I have been on the UN Security Council, presided over it. I have been fortunate enough to be the first president of the Assembly of States Parties for the International Criminal Court. I've worked in development, and I've had some understanding of humanitarian affairs. And so I don't understand when people talk of international community. What community? What community? In international fora, there used to be at certain times a collection or a gathering or a gravity of interest that would push a certain treaty forward and then sustain it. Not everyone would be for it. And every major development in human rights is led by a core group. In the last 20 years, this core group has sort of disappeared. And we don't see treaty making the way it was done in the 1990s, for example. Right? And if you take a treaty, one of the pivotal treaties, or take the Universal Declaration and try to negotiate exactly the same terms today, could we do it, Roderick? Could we do it? We could never even get close to it now. So there is no community. You know, we're very dangerously placed now, and we have to get away in thinking that somehow we're all bound by the collective interest. It's not there, and that's the danger.
Thanks. I still hope there is a community, an international community of shared values and interests, but you know, your caution, that's the point you're making, I think, is extremely pertinent, which is that we're seeing such a breakdown in the support for the international rule of law, and I think it's a very pertinent cautionary comment. So thank you very much. Please go ahead.
The International Criminal Court is a court of last resort. It is not a court of first instance, which means that states who are parties to the Rome Statute still have the primary responsibility to investigate and prosecute these atrocity crimes when it happens on their territory. The gathering that was in that was pushing the creation, I don't want to say international community. So the gathering that had, that negotiated the treaty and have this principle of complementarity, which is the heart of the Rome Statute, what they had in mind is that if states continue to retain this responsibility to investigate and prosecute, they will have the incentive to develop their own domestic jurisdiction to the extent that ICC will certainly, definitely remain to be a court of last resort. And if you look at the success of ICC, what it can be that it has a few cases. And what that means is that because national jurisdictions are taking up their responsibility to investigate and prosecute, therefore, the need for ICC's intervention in many situations will be minimal and not a lot of cases coming to the ICC. I think this is really one of the concepts that this gathering had in mind. I mean, this was one of the things that was the incentives of driving the creation of the court, but at the same time ensuring that domestic jurisdiction are also working they're implementing legislation, they're investigating, they're prosecuting, so that matters don't go to the ICC. So in that regard, I really would not say that the international community, I think I can use that here, I mean, we're really not standing by for and only having this institution like the ICC to do all the work. Really, the intention was that domestic jurisdictions will also function as it should.
Please.
Thank you. Well, I can only echo the profound pessimism of the High Commissioner. We are moving to a very polycentric world, I'm very happy actually that the Rome Treaty was negotiated in 1998. I would be very surprised if it would be possible to do it today. I think the world has changed dramatically, and so the situation is really serious. And a lot of countries which were very much engaged in supporting international criminal justice are today quite timid in supporting you. And I think it's a very revealing factor of a change of attitude, mentality, spirits, and expectations. The fact also that Western Europe is not taking the lead anymore. With a situation like Syria, when you have almost 5 million refugees, 300,000 dead, more than half of the population which has been displaced, is telling a lot of the situation and of the inability of a lack of political will to deal with such a terrible situation.
Let me maybe join a more optimistic vision. I think, I mean, we've seen a huge rise of international institutionalism over the past decades, but I think historically we're to some extent at a breaking point where our internationalized models get ever more diversified and where we see a certain decentralization of justice. And I fully agree that many of the colonial critiques are exaggerated, and that why are they voiced by the perpetrators and not by the victims, right? So there's many false rhetoric in there. But there's, of course, also a deeper critique of international justice, that international justice promotes global justice rather than local justice. There are legitimate concerns to what extent international criminal justice is based on basically on a retributive rather than a distributive model, to what extent it allows pluralism of justice responses, or whether it constrains actually some of the alternative forms of justice. So, but I think we actually, while I agree that we face a certain crisis in internationalism, we also see new creativity. We see new hybrid courts in CAR, in South Sudan. We see new regional mechanisms emerging. We see in Guatemala sexual crimes being investigated and prosecuted. We see internationalized prosecutions, basically, where international prosecutors support domestic prosecutors. So while I agree that international criminal justice as an international system faces severe challenges, on the other hand, we also face certain very interesting new developments, I think, which should be seen in context.
Thanks very much. I think we have a balance between, I wouldn't call it pessimism, but realism, if you would call it that, and optimism, which is realistic optimism. So we're coming down to a neutral and independent view, and that's appropriate for the ICC. Let us open the floor to the audience and see what comes up. And I would ask you to keep your questions brief, with not too much background, because I think people know many things about international criminal law and about the frameworks. And if you can be a little bit telegraphic in your questions, and also respondents, or maybe you want to direct your question to a particular person, and you can just quickly say your name and you know that, and then make a succinct intervention, and then we'll have succinct responses so we can cover as many responses as possible. And we have a half an hour of this free-for-all. Let us start with somebody here. I see in the third row. Please go ahead. Do we have a roving mic here that maybe I'll ask you to come all the way down here, if I may. Yes, excellent.
Thank you. What an honor to open the floor. My name is Patricia Bellego. I'm from Leiden University. I would have a question for the High Commissioner, wanting to know what are your thoughts on the weight of victims in the participation of ICC proceedings, in the fact that it hasn't been very clear on each proceedings and cases where what they're able to do and the weight that they're able to have in their participation. Thank you very much.
Thanks. We're going to take 2 more questions and then take them in groups of 3s. So let's see somebody from this side of the room. I saw your hand very early with the yellow. And I'm doing this a little bit unscientifically because I didn't take a clear account of who put their hands up immediately. But please go ahead.
Well, thank you very much, Mr. Chairman, and thank you also to the organisers for this panel. One comment in passing is that, although obviously it's a very, very distinguished panel, I'm afraid it does seem to be slightly incestuous. So we're here at a seat of learning, and I don't really see anyone who is there to express a ICC skeptical viewpoints, and I think we've all conceded that there are, in fact, a number of those people, institutions, and governments around. What I think hasn't been said is that...
I'm looking for a question, not so much a statement. You're going to come to it.
Sure. What hasn't been said, I think, is that there is actually a gaping hole in the whole issue of accountability. And my question is, what mechanisms can be put into place to make the ICC more accountable? The difficulty with the ICC is that, in fact, it's not independent. It has given special prosecutorial rights to the UN Security Council, the world's most political body, and is actually tied umbilically and financially to the European Union, who actually provide, I think, looking at the Assembly of State Parties financial reports last year, anywhere between 60 and 76% of its funding. My question specifically to the prosecutor is, you've mentioned resources. How is it that you can actually, for several years, avoid bringing any indictments with regards to the tens of thousands of civilians who have been burnt alive or bombed to death in Afghanistan by NATO forces, allegedly? Okay,
this is a very, very loaded and tendentious question, but I think we got the...
allegedly, when in fact you spend huge amounts of money in prosecuting one person for actually burning down or destroying one building in Mali. So
I got you. We got your question. Yeah. So next, to allow other people, do we have another? Let's say, let's also gender balance. Is there a woman that prefer to also? Yeah. Yes, please go ahead.
Thank you.
Please keep it succinct and to the point. Thanks.
I would like to ask High Commissioner Zeid and Prosecutor Fatou Bensouda whether they would consider collaborating on a specific point, and that's to expand the definition of genocide to include the cultural aspects of the crime, which was the initial definition of the Genocide Convention. The first 2 committees which drafted it, and Raphael Lemkin's intention. He was the actual, the person who coined the word genocide. And so I wanted to you to address this because Commissioner Zeid mentioned the fact that the OHCHR's role is in monitoring and finding out whether there's such situations that could escalate. And in my view, the crime of genocide is always preceded by hate, xenophobia, and what we call violations of minorities' rights and cultural rights. So could you please address how you could combine, how could you join forces to work on this definition? Thanks.
Thanks very much. And I'm just going to take one fourth one quickly. Peter Splinter, I saw your hand.
Thank you. Very interesting discussion. My name is Peter Splinter. There seems to be a tendency to equate accountability with criminal justice. One sees that in the Human Rights Council. One sees that in many places. And personally, I think that's a troubling equation because it leads to not looking into other avenues of accountability. That said, I'm not challenging or questioning the crucial importance of criminal justice, but I think accountability is more than that. So my question in particular to Prosecutor Bensouda and High Commissioner Zeid, but to anyone who wants to answer, it's two questions actually. Is there a balance to be struck between pursuing accountability through criminal justice and pursuing accountability through other avenues, other mechanisms? And if there is a balance to be struck, how is that balance to be pursued? Thank you.
Thanks very much. I would invite Madam Prosecutor to address the questions, not so much the statements, but the questions.
Yes. There was the first question on victims and proceedings at the ICC, which was directed to High Commissioner. And well, maybe, I don't know, you're asking for another perspective from the High Commissioner, but I thought that as prosecutor and also being the first international court that allows the participation of victims and witnesses in proceedings as parties and participants, I thought maybe I should also respond to that question. As you know, at the very beginning, firstly, I would like to say that the participation of victims at the ICC is not a privilege. It's a right that has been granted to them. It is not the prosecutor granting it. It's not the defense. They have this right to have their views and concerns during the proceedings. In fact, we saw that happening in all the cases now, but for the first time, it was in the Lubanga case that participation of victims took place. Of course, being the first time and being the first case of that nature at that level, we had to grapple with the modalities of participation. But I pretty much think that at the moment, this is quite settled before the ICC in the subsequent cases that follow. In the Katanga, in the Bemba, in all the other cases, this has been, I think, fairly regulated by the judges, and it is happening. And of course, we had our first reparation also in the Lubanga case. So I think it's working. That's what I can say. But of course, I mean, there may be other views about that, but I believe that it is working. What it was intended to do, not become prosecutors themselves, but become victims who are affected by what has happened on the conduct, especially of the accused before the court, and how it has affected them has been really more or less the criteria the judges have been using to allow participation in the proceedings. And as I said, I think this is working.
High Commissioner, would you like to respond, and then I'll...
To this question, or just to a number of them? Okay, I'll quickly run through them. The issue regarding the independence of the court, I have to say this makes me very angry. It's a very, a point that I simply don't understand. When you have a world where capital markets are valued at $36 trillion, that's a lot of money. That's a lot of money. A few $100 million for a court or for the human rights architecture, it's nothing. Absolutely nothing, and to make a big deal out of it. As I said, you know, my office has as a budget 1/10 of what in Switzerland is spent on chocolate every year. Right? That's the context in which we're operating. Also, when you look at the way things change, in 2002, when the Rome Statute entered into force, and I was presiding over the court, we had great support from the African continent, and the court was being attacked in its infancy by the United States of America, and the Congress, remember, passed what was called affectionately the Hague Invasion Act, that anyone surrendered to the court would be rescued by the U.S. Marines who would invade this fine gentleman's country. There were 2 resolutions passed in the UN Security Council presented by the United States, Article 16 resolutions, which were adopted. with France and the UK supporting. And the court's main antagonists were from the north, not from the south. Right? We managed to get through this phase, and everyone said, if the court can survive these early days, then it can get through. So now we have a different situation, but to sort of assume that it's doomed and dead. And to the skeptics, the argument always was, well, can you come up with something better? Give us a better alternative. You know, and so many different variations were thought of, but all of them not as good as the International Criminal Court. So for the naysayers, well, come up with something then. I mean, come do some work yourself. But if you are like the rest of us who've witnessed these abominations of violations, you know, to say and assume that, you know, we can sit there and cast all sort of, doubts, I think is irresponsible. Sorry, there was another, and then a cultural genocide. I mean, yes, I mean, in terms of the provisions of the Rome Statute, I mean, those provisions can be amended where they depart from customary law. And there was, of course, a great push at the time to have treaty law included. That was excluded, and so the core crimes were where they are. But the point being made that the barometer is very sensitive, and when you see attacks on cultural heritage, on language, on minority rights, the rights of all human beings, then you begin to sense that something is going awry. Final point from Peter. I don't think I understood the question, Peter. Forgive me, that's my fault. But you were saying other venues for accountability. Yes, I mean, we had these discussions about this. In the end, though, we have seen in many respects where you had truth-telling but no accountability. In the end, the pressures don't go away in society, and the victims still feel that their grievances have not been addressed. There is a sort of temporary balm that's sort of placed on the wound, but the wound nonetheless exists, waiting just for the bigot, the chauvinist, the ethnic nationalist to dig it all up again. And so I think after 6,000 years of experimenting, we've realized that, no, you have to have accountability in its proper form.
Thanks very much. By the way, on cultural genocide, if you look in the travaux préparatoires to the Genocide Convention, you'll see that it was debated and explicitly rejected as well. Carsten, did you have any comments on the questions? And then I'll go to Pierre.
So, I mean, on the victims question, I think we simply have to realize we're facing something new. It simply hasn't been done before in that way. I mean, the ICC has now the fifth model, obviously, of dealing with victim participation. So, but it's clear. I mean, since this is a new paradigm, there is no solution that you find in domestic law which actually matches what can be done internationally. So it's only natural that there's some procedural experimentation. Obviously, the judges are now through the practice manuals are trying to address some of this. The main question is, of course, there will always be victims which are left out of the process. That is the fundamental question, obviously, of victim participation and reparation. So how do you deal with these exclusions? And I think here again, I think in the context of the reparations, we see new formulas where the reparations that are awarded basically extend right to broader communities. And secondly, we just have to think about making the trust fund model work a little bit better. So to really think also about alternatives, as was mentioned, criminal accountability is not always the solution to the problems that we're facing. So sometimes civil models, and particularly also in relation to reparation, then basically the assistance mandate of the trust fund might be a much more effective, quicker, and better and more just way to resolve some of these dilemmas than trying to solve everything through judicial litigation.
Yeah. I'm struck, I'm just thinking about the question regarding other avenues than criminal justice. And I'm struck by the example of Central African Republic. You know that 2 years ago, the country was close to a genocide. It was qualified as a pre-genocide situation by the UN. And today, the situation has improved slightly. Well, there's a new government, and there is a roadmap to peace. And what is interesting, you have different layers of justice. You have the ICC, and there is the upcoming special court, which will be created very soon. Then you have national courts. Then you have a truth commission, which has to be created very soon. And then you have traditional conflict resolution methods, which will also be used. So basically, you have 5 different layers of justice. So the question for me is, how are they interacting between the different layers? Are they duplication or not? Are they contradictions? Are they tensions? There are a lot of questions regarding the architecture, but in terms of invention, a lot of things are happening. We'll see the results, but the creativity is here.
Thanks. Angela, did you want to add anything further? And
Very briefly, just to say, I think it's a good question. Are there other alternatives to criminal justice? And as Pierre has already said, there is a balance to be struck, and everybody quickly refers to the situation and example in South Africa with the Truth and Reconciliation Commission, which for many was an unsatisfactory compromise. One of my cases today is my client, her sister was tortured and disappeared by apartheid police 35 years ago. And we know from the Truth and Reconciliation process who abducted her, who tortured her, and subsequently who murdered her. Yet that person has not been prosecuted. And it's a battle we continue to fight today. It's not a very good model to sweep things under the rug. So there is a delicate balance to be struck.
Thank you. And if anybody else wanted to comment on the last set of questions, and then we can maybe take 1 or 2 more after that.
Yes. From the audience. I think there was the question answered from, asked by the participant about the percentage that the European Union contributes to the ICC, and therefore they dictate what the ICC is doing, that there is no independence. Actually, this is a question that I notice those who are advancing the cause of Sudan, of course, always ask. They always put forward. Yesterday, even in the briefing, I got a similar question on that. And I remember exactly a couple of months ago, the same participant has raised the same issue in Ghana when I went there for a conference. But I wanted to say that I really think that it is kind of dishonest to keep saying this, advancing this issue, that if you take all the contributions of the European countries together, which forms a certain percentage, I don't have it offhand, therefore they are contributing more to the ICC, and therefore they are controlling the ICC. I think this is very unfair, and it is actually not correct that this is being advanced all the time now. I think it's one of the latest attacks on the court. The members of the European Union are members of the ICC, and they are members of the ICC in their individual capacities. They have obligation, like any other state party from anywhere else, including Africa and Latin America, to subscribe to an institution that they have signed and ratified. This is the same thing that happens, I believe, at the United Nations. It is also what happens in many organizations. It's what happens at the African Union, I believe, that those who join these organizations and institutions, they have a subscription to pay. But it should not mean that it should be lumped together and say because their subscription is more, therefore they control the court. I really think this is quite unfair to say about the court, and it is not even realistic to say that about the institution. I have said several times already that this ICC, whether you accuse it of anything, whatever you want, is an independent institution that has been created by states parties to the Rome Statute, having obligations to this institution, and will do what they have to do as states parties to the Rome Statute to support the court, and that includes respecting the subscription that they have signed to, and also to contribute to the funding of the International Criminal Court.
Thank you very much. Now, I'm supposed to leave some time for closing statements, but instead we'll take one more question and only have a closing statement from the ICC prosecutor and the High Commissioner. So I'll take one more question. I see right beside you there's a woman in blue there, and again, gender balance. So we last start with Peter Splinter. Floor is yours. A succinct question.
Yeah, it's actually pretty succinct. So my question is actually from an academic perspective on international criminal law. The concept of liability, joint criminal enterprise, that was extremely well adopted or well encouraged within the ICTY, has not been embraced in the same way within the ICC. So my question would be, which has shifted more towards a co-perpetratorship type of liability instead of adopting joint criminal enterprise. Arguably, this could be the end of the theory of liability under that heading, because if the ICC doesn't use it further, it's likely to die out legally. So my question is there a deliberate shift, or is it that something that's academically been reviewed as something that no longer really holds value?
Thanks for your very well-framed question. Yes.
You're turning to the technician, the legal technician. So I think it's a fair point. We've certainly seen a certain movement away in the ICC from the concept of joint criminal enterprise. But don't forget, in the ICC we have a kind of ICC version of joint criminal enterprise, right, which is Article 25(3)d, which is kind of its own version. So my own take on it is actually that, I mean, some of the jurisprudence, if you compare it, and this is what research tends to show, that while we might have different concepts such as joint criminal enterprise or joint control, in the end, they might lead to similar results if it comes to the question about who is actually held accountable. Is JCE dead? No. I think if we look even this week, the conviction was based on JCE 3 and direct perpetration. So we will probably see to continue different models based, of course, on the jurisdiction of each tribunal to deal with criminal accountability. Obviously, I mean, one hope might be that in a certain amount of time, there might be a move towards a certain harmonization where we might actually see that, right, the concepts actually are compared a little bit more deeply. But I think at the moment we still, I think, live very much, I think, with this procedural pluralism. I think in the context of international crimes, we're moving very much towards greater harmonization of crimes, but as it stands with modes of liability and procedures, there will always remain a greater degree of diversity than I think in relation to crimes.
Thanks. We're running close on time. We're going to just go 5 minutes over, and then I will stop it at 3:05, because I cannot refuse the ambassador of Ghana. Excellency, please, would you like to raise something? Yeah, please. Thank you.
Thank you very much, and good afternoon. Thanks for your very brilliant presentations. I didn't see an African speaking from the audience, so I just lobbied for me to be allowed to support the campaign for advocacy for the court. And so if you indulge me, I'll speak for about a minute. And I'm looking at the human rights actors, and here I want to talk about the diplomat as a human rights actor. And in answer to, to address what the Commissioner said about hypocrisy, we have a challenge in the Human Rights Council that at the mention of accountability, there is no consensus. And accountability not just for criminal justice, but all forms of accountability. Once the word accountability is used, you see hell break loose. Ghana supported the special session on Burundi. We did support the resolution on South Sudan. In each case, I was fortunate enough to tell the ambassadors, that Mr. Ambassador of Sudan, Mr. Ambassador of Burundi, what we are doing is not about power, but it's about people. And we are still friends, luckily, because they accepted the idea and made statements to pledge cooperation. And so there's no time to answer a question from me, but I wanted to find out how can we break that jinx where we are being told that country situations or country-specific situations cannot be discussed at the Council. But the history of the development of human rights have been about country-specific situations, right from those who caused the war, through the colonial territories, through apartheid, and those days when the the South American dictatorships were going on, and countries from those regions were brought. Those countries which brought countries like Chile and Costa Rica to the General Assembly to be discussed because of military dictatorships are now fighting against country-specific situations. And now rather Chile and Costa Rica and the rest are defending country-specific situations. Let me conclude by saying that as a Ghanaian, it will be hypocritical for anybody to praise Ghana for where we've reached in terms of democracy and not accept country-specific situations. Because we are a product of a country-specific situations. When the ILO was discussing Ghana for freedom of association violations, we have been a product of international pressure to bring us where we are. Now, let me just sit down, before I say that, let me just say that the Assembly of State Parties of the ICC let African countries down, the African state parties down. When the African heads of state requested for an interpretation of the Rome Statute as to whether the immunity of heads of state should be, there should be an exception under the Rome Statute. I know that there's this irrelevance of official capacity. That was the compromise because of the experience we had with wars then. But here we are, one particular head of state has been indicted, and he has friends asking for interpretation. Let us focus on the legal argument. The other extraneous things about, only Africans have been targeted. We cannot have a geographical distribution of criminal justice. And if I can just make it's very important because I won't have the chance to address such topics. You see, we cannot have an equitable geographical distribution of criminal justice. In Nuremberg and Tokyo, Africans were not there because we didn't cause any war. You see, so criminal justice will follow the crime. So we cannot say that there should be a criminal trial of an Italian head of state because an African head of state is being tried. What about if there's so many trials in North Africa, and therefore the North Africans say that, why don't you go to Southern Africa? It cannot happen. And so the Security Council's role is a very good soundbite for people to say that, why is the Security Council an unelected body prosecuting people? It's a good soundbite, but it was Gabon and South Africa and the third African country which supported the indictment of Bashir. The reason we allowed that Security Council role is to ensure that there's no safe haven for impunity, so that you don't commit a crime in Ghana and go to Sudan and say that it's not a state party, so it cannot be tried. So that residual power has been given to the Security Council to be able to make sure that there's no safe haven. Now, the only problem I have with the current state of affairs is that it is the five powers who has failed to be parties to the treaty, which is giving legitimacy to those arguments. So what we have to do is to reach the ultimate goal of the Rome Statute right from the days of the Genocide Convention, when we thought of a permanent court which would derive its universal jurisdiction from a treaty document instead of customary international law. Now we've got that permanent court, and everybody's supposed to be a party to it. And when the matter came to the Assembly of State Parties, instead of the member states of the Rome Statute supporting the African countries in the Assembly, they told us to go and deal with Sudan ourselves. And that's where we are.
Thank you very much. If I can ask you, in responding, also to make a closing statement of a minute or so, and then, because I'm determined to end off at 5 after, as I promised.
and then closing statement. Yeah, no, go ahead.
If I can address the ambassador's remarks, and I'm a big fan of yours, so I'll deal with it in three parts. One, I agree of the centrality of the diplomat as agent, the individual as agent. We only have an international criminal court because we had individuals, the right individuals at the right time, negotiate and approve the statute. If we had changed the individuals, same countries, same governments, we may not have had that. So I agree with you entirely on that. When the African Union delegation came to The Hague, I had the fortune of chairing the panel to deal with the Article 27 challenge. And I had a number of distinguished delegates or academics on the panel. And the way that it was resolved, Ambassador, was not a discussion between the states parties from the north or the states and the states parties from the African Union. The way that it was discussed is that you had the countries, the 6 countries with their attorney generals and distinguished ministers, having a dialogue with the African NGOs who were present. And the rest of us were just listening to this. And at one stage, the Attorney General of Kenya said, you know, we should have had this discussion in Nairobi. And it was a very respectful, very dignified discussion of high caliber. And I think ultimately this is how you unlock these issues. It's a discussion between governments and their people, between governments and victims groups. And we can unlock it in that way. The Security Council, I think it's worth reminding ourselves that we're only 2 ratifications away from the entry into force of the Amendment on Aggression. And as you well know, what will happen there, we need a decision on it in 2017, is that if there is an act of aggression, the Security Council under Article 39 can make a determination. If they don't make a determination in 6 months, the jurisdiction of the court kicks in, basically, on account of the crime of aggression. So what was seen by many as an exclusive right under Article 39, that the Security Council shall determine an act of aggression, is not quite there. And you might find in the last few years there have been cases where members of the Security Council would be vulnerable to ICC jurisdiction in that regard. So I think when looking at this, we have to take the long view. You know, there was a time in 1994, 1995, and I remember it distinctly. I was in a meeting with Boutros Ghali and other UN officials, and I had just come from the former Yugoslavia. And at the time, there was a heavy concentration on ending the war in the former Yugoslavia. And there was a great hue and cry from the African leadership of, you are ignoring us. After Somalia, Africa is abandoned. And Boutros Ghali said to the rest of us, what can we do to help Africa? And so we go through these it's a long wavelength, and we shouldn't take it in small parts. And I think your activism in support of international justice and the human rights agenda is very much to the point that we have achieved a great deal, and this goes to Carsten's point. We have achieved a great deal. We have a lot to protect and something to save. Yeah? So we just can't lose it. And that's why we have to redouble our efforts at the moment. Thank you.
Thanks very much. And would that also be your closing statement?
Yes.
Good. Final word for the prosecutor?
Yes, it's again an opportunity to thank the fellow panelists. I think it has been quite interesting, but also to thank Ambassador for organizing this. For us, ICC, it's crucially important that we maintain this interaction between the ICC and the Geneva-based institutions. It's absolutely important. And I just want to, maybe just one short sentence, to say that we need to remind ourselves consistently and constantly of the reason why we felt there was need to establish an international criminal court, a permanent court that will be able to look into these atrocities when they are committed if the national jurisdictions fail. The resolve then was to ensure that there is no longer impunity for these atrocity crimes. And I think that resolve should continue. The ICC needs the support of its states parties, but also of other partners to effectively do what it was set up to do. And a lot of that, of course, depends on the cooperation and the support that we should and continue to receive from the states parties, from partners, from other international organizations, but also even from domestic jurisdiction. So this is important to really see the effectiveness of the court, and I thank you.
Well, I think, yeah, thank you. No, not a problem. Thanks very much. I want to thank Ambassador van Schreven and the Graduate Institute and Madam Prosecutor and the ICC and the High Commissioner for Human Rights and all the panelists and all you for coming. For me, it's been a fascinating experience. And we started at 10 after, and it's only 7 after, so we saved 3 minutes. And time is, in any case, an illusion. So, so thank you all, and see you hopefully next time at another occasion. Thank you very much.